Good morning, everyone. People are still joining us, but since it's now 11:01 and we were due to start at 11, I think we better begin. Thank you very much for joining my Chambers colleague, Chloe Shuffrey, and me for the latest in our Radcliffe Chambers Commercial Insights webinars. Now, it's something of a cliche, to put it mildly, to say that we live in interesting and unsettling times, if only they were just interesting. Now, until 2022, the number of commercial lawyers doing sanctions work was relatively small. Those involved with the Russian legal market might have had some dealings with the sanctions which were imposed after the occupation of Crimea in 2014. And depending on your practice, Iran, Venezuela, and a few other jurisdictions might have featured. But it was essentially a niche area. And of course, since February 2022, however you describe those events, the landscape has changed drastically and continues to develop. I was looking this morning and I saw that the Russia Sanctions Regulations have grown from 64 pages when they were first enacted to 489 as at this morning. I imagine they will grow further. But the message, of course, is that the influence of sanctions is now hard to escape in quite a lot of international commercial litigation. Now, sanctions are instruments of foreign policy. So they're about politics. But of course, they require legal expression and effect. But any idea that one might have had that sanctions regulations, when enacted, simply become a congruent and harmonious part of the existing law is, of course, fantasy. And certainly in my experience, and I imagine the experience of many of you, it's often a question of collision rather than harmony, even when it is clear what the sanctions regulations mean. Which of course is a slightly barbed remark, considering some of the things we're going to talk about a bit later. Now, we could have talked this morning about any number of different aspects of UK sanctions law, and a couple that come to mind as being of interest and importance are the effect of sanctions on commercial contracts, entirely different question of what legal services to designated parties or Russian parties generally UK lawyers can now lawfully provide. And perhaps Chloe and I will speak about those in future webinars. But today we've decided to focus on the Court of Appeal's decision in Mints. Now, I say that with a degree of reluctance, having talked about Mints and ownership and control at a London Sanctions Advisors event, which we held in December, and also Dubai Arbitration Week in November. And I'm also in the midst of arguing about ownership and control in a Stockholm arbitration where it is a central issue. So in one sense, I feel a bit tired of the subject, but we decided that Mints is inescapably topical and important. And we've decided to split it into two parts. The first is to begin with what Mints was about briefly and what it actually decides and decides in a relatively clear and positive way. The second part will be what else Mint says. And of course, I mean by that about the issues of ownership and control. Now, like any bad leader, I've asked my junior to deal with the second, more difficult aspect. Please forgive me if what I'm about to say is very familiar to you, but I'm going to kind of skate over the background facts quite quickly. Now, Mr. Mintz and others, including some members of his family, are defendants to a rather large conspiracy claim in the High Court in London. Now, the claimants in that claim are two well-known Russian banks. The first is National Bank Trust, and the second is Bank Otkrity. Now, Otkrity is specifically designated under UK sanctions regulations, but National Bank Trust is not. So the question arises in Mints, what the effect in these circumstances of the Russia Sanctions Regulations 2019, 496 pages, as I've mentioned, is on this litigation. Now, the defendants, as you well might in their position, applied to stay the proceedings before the High Court. And they did that on essentially two grounds. So the first, which was later described as the entry of judgment issue, contended that judgment could not be entered in favor of designated parties because either it involves making funds available to such a person, which would infringe Regulation 12 of the Russia Sanctions Regulations, or it would otherwise be inconsistent with the asset freeze under Regulation 11. And just pausing there, I mean, what I always think and always say to people is never underestimate the broad and sometimes even counterintuitively broad effect of the asset freeze in the case of designated parties. In any event, the second ground, which ended up being called the licensing issue by the courts that dealt with this application, a second ground for seeking a stay was that the defendant said that they would be seriously prejudiced by the inability, as they said it was, of a designated party to pay things like adverse costs orders, security for costs orders, damages on cross undertakings, obviously quite important in a fraud case. So there are really two issues. The entry of judgment issue is one might describe as one of principle. The licensing issue is much more concerned with the kind of nuts and bolts of the sorts of thing that one would need to be able to do in terms of payments backwards and forwards during the course of proceedings in order for those proceedings to function and proceed in an orderly and fair way. Now, as I've mentioned, Shuffrey is designated under the Russian Sanctions Regulations, so there was no question about its status. And we'll come in a minute to what the effect of that status was on its ability to claim. Now, National Bank Trust, on the other hand, was not designated, but UK sanctions law extends the consequences of designation, things like asset freeze and the various prohibitions on making funds and economic resources available, to entities who are owned and or controlled directly or indirectly by designated parties. And so the argument of the defendants in relation to National Bank Trust is that since it was 99% owned by the Central Bank of the Russian Federation, it was therefore controlled by either or both of President Putin or the governor of the Central Bank of Russia, Mrs. Naibulina. And for that reason, it was subject to the same restrictions as if it was specifically designated, like Otkritti. So the net argument was that both claimants were effectively designated and therefore unable, so the defendants claimed, to proceed with the claim, either because of the things they couldn't do in terms of making payments during the course of proceedings or to obtain judgment if they were successful. Now, just dealing with the way that was dealt with both at first instance and in the Court of Appeal, and let's do it in reverse order. So if we look at the next slide, this is the licensing issue. And what the court held was that, and there's a list of things which the court had no doubt that OFSI could license if an application was made by a designated person in relation to proceedings in which it was a claimant and one might think also defendant. And this was purely a matter of the interpretation of the Schedule 5 to the 2019 regulations licensing criteria. So obviously it doesn't have a total discretion on what it can license. There are certain categories, but the court had no doubt that these four, very important depending on the facts of the case, kinds of payment which might need to be made during the course of proceeding could all be licensed. And so that was the answer in practice to the argument that the defendants would be fatally disadvantaged in litigation because these things could not be done. Turning then to the next issue, so this is the entry of judgment issue, the court decided two things, had regard, should I say, to two things. The first was that the entry of judgment, and we'll come in a moment to quite what that means, on a cause of action is not prohibited by either Regulation 11, the asset freeze, or Regulation 12 of the Russia regulations. And that was on the basis of an ordinary interpretation of what those regulations say. And although the court regarded a cause of action, so the thing which is the basis of your claim, as being an economic resource, it didn't consider that entry of judgment had the effect of making funds available to a designated person in contravention of Regulation 12. Now, the distinction here is between entering judgment and enforcing a judgment. Now, enforcing a judgment, in other words, deploying the court's coercive powers to make a reluctant judgment debtor pay, is a different matter because that would involve taking steps, the effect and purpose of which would be to make funds available to a designated person. But entry of judgment is not prohibited. Now, for that reason, the court didn't need to go any further, but it did express the view that what is sometimes called the principle of legality is engaged in, or was engaged in this case. Now, as many of you will know, and I'm conscious that there are people tuning in lots of other jurisdictions, but the UK Parliament can do anything. It can legislate to say anything. And there have been some recent examples of that in other contexts. But when it legislates, its legislation needs to be interpreted. And the principle of legality means that there are certain fundamental rights under English law, which, although Parliament can override, it would need to do so in very clear terms. And the Court of Appeal didn't consider that the Russia sanctions regulations did that either. So a number of questions occur to me anyway about what this aspect of the decision means. I mean, it's obviously relatively clear. I mean, it has certain implications that maybe need to be worked out, but maybe its conclusions are not surprising. And I think they're quite welcome, both from a kind of access to justice and rule of law perspective. But one of the questions that occurs to me is whether it applies to arbitration. You'd think that certainly the reasoning in relation to entry of judgment not constituting the making of funds available or contravening the Regulation 11 asset freeze would apply to the making of an award. And once again, a different consideration would apply if you were to take your award off to the commercial court with a view to enforcing it. But Chloe, I know that we discussed beforehand different approaches in other jurisdictions, perhaps on this point.
Yes, well, it's worth observing that at one point in the Mint's judgment, the Court of Appeal did say that the Samler post-Brexit UK sanctions regime doesn't in fact have any substantive changes from the EU regulation, i.e. Regulation 269 of 2014. It's just that the wording has been significantly recast. Whether that's correct or not, people may have some disagreement about that. But certainly it was their view that there were no substantive changes. And when you look at the EU regulation, generally where it refers to judicial decisions, in the same sentence it refers to arbitration awards. So one might expect that if the Court of Appeal's view is that we haven't changed substantively from that, that the same reasoning that applies to the entry of judgment in courts would apply to giving an award at the arbitration level. But I don't think it was expressly, there was any express view given either way on that.
No, and I think that, I mean, in one of there have been many hearings in the Mint litigation, and one was about an LCIA arbitration. I think where an award was made and some of the Mint defendants were parties, and there was a kind of raised judicata argument that the claimant banks tried to amend to include, and I think that was refused. But you're right. I think when it came to this stay application, the question of arbitration doesn't seem to have figured at all. I mean, I agree with you. The idea that the European regulations from which we've departed are effectively the same, I think is one that needs quite a lot of close examination. But one point it does raise is that the Mint's decision, I think, is quite interesting in that there's quite a long description of how the whole international sanctions, economic sanctions regime arises, and how we've ended up with our own, and how that relates to UN and EU sanctions regulations, which is actually worth a read. I mean, I think both as a matter of kind of historical interest, but also, but if you want to know how these things are meant to work and why our regulations operate in the way that they do, it's actually quite a good guide to that, even if one is perhaps doubtful about some of the similarities that the Court of Appeal draws attention to. But moving on, I mean, there's also the question of licensing. We've touched on that in relation to payments made to and from a designated party during the course of litigation. But the question obviously arises, well, if it's not in breach of the regulations to enter judgment, what about enforcement if the claimant is a claimant judgment creditor is a designated person? Well, I mean, I think if one looks at the licensing grounds in Schedule 5 to the regulations, it's fairly clear that in most cases anyway, that the designated person's rights which are, form the basis of the judgment in its favour, those have to have arisen before the designation of the designation party for OFSI to be able to license enforcement. But that then raises the question, why would you bother to bring proceedings and take lots of time and spend lots of money to obtain a judgment which you can't enforce? Which takes us, I think, to the next slide. Now, of course, a second thought, and you can think of reasons why one might want to do that, and there may be limitation issues, for example. It might, as we suggest here, be relevant in proceedings in other jurisdictions for the claimant's rights to be decided in UK proceedings. But there is also the question of enforcement in other jurisdictions, which is potentially a very good reason for a designated person to want to bring proceedings and obtain judgment here, which could not be enforced here. Because if the other side, the judgment debtor, has assets in a jurisdiction which doesn't apply sanctions regulations that might impede enforcement, then you could go off, one might think, with the judgment with a view to enforcing it. I have to say, having looked briefly, I admit, at Part 40 of the Civil Proceedings Rules, trying to work out quite what entry of judgment means, it is not obvious to me. But I assume that if you go off to take a random example, Turkey, to enforce a judgment, you need a sealed copy of the court's order. And assuming you can get that in a case like this, that could be a very good reason why you might want to bring proceedings.
The only other thought I had on that, Shantanu, is perhaps a sanctioned party could get their judgment in the UK courts and then go about selling or assigning it for value, because of course the UK sanctions regime has limited extraterritorial effect. So if you're talking about someone who's a Russian national resident in Russia, designated under the UK sanctions list, they can nevertheless get their judgment in the UK court. But then when they're in Russia, they're not subject to the UK asset freeze or any other sanctions. They can go about selling their judgment debt for value, although query whether it would be a sensible move for the assignee to take that assignment and then have the trouble of going about enforcing that judgment debt themselves in the English court. So they're not a designated entity, but query whether that might then breach the circumvention prohibition. But that's perhaps a tricky issue for another day. But that's just another way around, potentially around the issue of enforcement as opposed to entry of judgment.
Yes, and in fact, it reminds me, after you raised this, I did actually remember that I had an inquiry about advising about an assignment. I can't remember the exact facts, but one of the things that collided with, as it were, is quite what we're entitled to, well, permitted to advise on at the moment, after the insertion of Regulation 54D. But as I say, I think that's probably a subject for a different webinar. But moving on then, I think, to the question of ownership and control. I mean, what is, I think, obvious from the effect of what Regulation 11 and Regulation 12 and Regulation 13 say. In other words, that the consequences or the prohibitions in those regulations apply to entities which are owned and controlled by designated parties. Obviously has the consequence that the consolidated list of financial sanctions targets, as it's called, which is published by OFSI, is not an exhaustive statement of the entities which are subject to an asset freeze and other restrictions. But how do you go about telling? And that takes us on, I think, reasonably neatly to what Chloe is going to tell us about ownership and or control.
Thank you, Shantanu. And I'm afraid I will be telling you some things, but probably raising more questions than answers. The issue of Regulation 7.4 and ownership and control remains a very vexed one. And it's hardly helpful that we've had two quite different judicial approaches in the only two authorities that currently exist on that provision, namely Mints and Litasco. But before I come to those judgments, I just want briefly to consider the actual wording of Regulation 7.4. And you'll see on your screens that I've put up Regulation 7 in its entirety. So this is where the regulations define two conditions in which an entity will be owned or controlled by a designated person. The first condition is contained in sub-paragraph 2. I won't read that out in full, but safe to say it's relatively clearly and precisely defined, and Schedule 1 contains considerably detailed definitions of, for example, what it means to hold a right indirectly in another person, albeit that's not to say that it's always easy in practice to establish on the facts whether the first condition is met. But then turning to the second condition with which we're concerned, contained in Regulation 7.4, you can see that this is somewhat more broadly and more loosely defined. The second condition is that it is reasonable, having regard to all the circumstances, to expect that P being the designated individual, would, if P chose to, be able in most cases or in significant respects, by whatever means, and whether directly or indirectly, to achieve the results that affairs of C, which is the company or entity in question, are conducted in accordance with P's wishes. And I think the first thing to note is the words "it is reasonable," which clearly designates an objective test or an objective assessment. Would the hypothetical reasonable person consider that P, the designated person, is able to control, as it were, the entity in question? But then when it comes to the words "having regard to all the circumstances," I think perhaps what isn't clear is whether that means all the circumstances that in fact exist and are possibly knowable, or whether it means such circumstances as are known or ought to be known if you've done proper due diligence to the person reading and relying on this provision, i.e. the person carrying out the reasonableness assessment. And if we just consider in comparison for a minute the wording of Regulation 11, which is the asset freeze provision with which many of you may be familiar, that reads, a person P must not deal with funds or economic resources owned, held or controlled by a designated person if P knows or has reasonable cause to suspect that P is dealing with such funds or economic resources. So that is clearly about the subjective knowledge of the person reading and relying on the provision and at whom the sanction is aimed. Does that person know, or do they have reasonable cause to suspect, i.e. based on the facts and circumstances known to them, that they're dealing with the assets of a designated entity? But coming back to the wording of Regulation 7.4, in contrast, at first blush at least, it doesn't appear to be about the state of knowledge of the particular person relying on the provision. The wording is, it is reasonable to expect that, not P has reasonable cause to suspect that. So it appears to be talking about an objective state of affairs as to whether an entity is in fact under the control of a designated person. But if that's the case, then it's not entirely clear why the provision was not drafted as follows, namely, the second condition is that P would, if P chose to, be able in most cases or in significant respects, etc., to control the entity. The fact that it's instead drafted in terms of whether it's reasonable to expect that state of affairs perhaps does suggest that, like Regulation 11, it's subject to the reader's knowledge of the circumstances. And the problem with that is that whether it is reasonable to expect that an entity is under the control of a designated person, i.e. whether that test is met, is almost certainly going to differ from person to person depending on the extent of their knowledge of the circumstances. But anyway, moving on from my musings on Regulation 7.4 to judicial musings, which unfortunately don't shed much light on that particular issue. Shantanu has already addressed you on what Mintz actually decided and the res judicata aspects of that decision. But as many of you are likely to be aware, the Court of Appeal towards the end of the judgment also made some rather explosive obiter observations about the ownership and control test, and concluded, contrary to what the High Court had held, that there was no carve-out to the ownership and control test for control exercised through political office. And accordingly, it could be said that Mr. Putin, who is of course a designated person, may be deemed to control everything in Russia for the purposes of the regulations. And I've cited their paragraph 233, where the Chancellor said, Mr. Putin is at the apex of a command economy. In those circumstances, in a very real sense, and certainly in the sense of Regulation 7.4, Mr. Putin could be deemed to control everything in Russia. Cue shockwaves and alarm bells ringing throughout the commercial world, in particular banks, as to whether they're then prevented from dealing with the assets of all and any Russian companies. There's no need really to dwell too much on what the Court of Appeal meant here. It has, of course, been observed that not only were these comments obiter, but the Court of Appeal, in fact, stopped short of saying that everything is, in fact, controlled by President Putin, rather than he could be deemed to control every company in Russia. So these observations were couched in somewhat tentative terms. And in any event, this decision has somewhat been overtaken by the High Court decision in Litasco, which I will come to. But it's worth, before we get to Litasco, just briefly observing some of the more general comments in Mintz about Regulation 7.4. They weren't really considering or analysing the wording of Regulation 7.4 in any great detail, and they were really only looking at it through the lens of the question whether Regulation 7.4 control might be directed at persons who have control over entities by virtue of their political office. But in so doing, they noted that the wording of Regulation 7.4 was wide, that there's no limits to the mechanisms by which someone might be able to exercise control over an entity. And what is perhaps more noteworthy, that Regulation 7.4 is ultimately about whether the designated person calls the shots in respect of the entity in question. And that particular expression is picked up in Litasco, as we will come on to see. So much for Mintz. Litasco was a judgment of Mr. Justice Foxton handed down on the 15th of November last year, and it's the first binding decision by UK courts relating to the control test under Regulation 7.4. Just in terms of the background and the facts, it was a judgment on an application for summary judgment, and it concerned a dispute over the sale of a cargo of crude oil, in respect of which the defendant had failed to pay the balance of the purchase price to the claimant, Litasco SA. Litasco is a Swiss entity, a company incorporated in Switzerland, wholly owned by Lukoil PJSC, a Russian oil company. Neither of those companies are themselves designated entities. Litasco alleged that it was owed 48 million euros by the defendant, in response to which the defendant raised various defences, on which Mr. Justice Foxton was giving summary judgment. And one of those defences was a sanctions defence under the Russia Regulations 2019. Namely, despite the fact that neither Litasco nor its parent Lukoil were themselves sanctioned entities, they were, on the basis of what the Court of Appeal had said in Mintz, at least arguably controlled by President Putin within the meaning of Regulation 7.4, meaning they were subject to the asset freeze sanction, and thus the defendant's payment obligations under the contract were suspended or extinguished. Now, Mr. Justice Foxton considered the comments in Mintz about President Putin and control and observed quite sensibly, I think, that those comments ought to be seen in the context of that decision. The entity with which Mintz was concerned was a National Bank Trust, which, as Shantanu pointed out, is a 99% owned subsidiary of the Central Bank of Russia, whose governor is in turn appointed by the Duma on the recommendation of the president. And as Mr. Justice Foxton observed, it's perhaps not surprising then that it was conceded in Mintz that National Bank Trust was subject to the control of Putin. In Litasco, on the other hand, there simply wasn't any evidence at all that either Litasco or its parent Lukoil were, which are not state-owned bodies, were under the de facto control of President Putin. And Mr. Justice Foxton notably went on to say that he would be prepared to assume that President Putin had the means of placing all of Litasco and or its assets under his control, should he decide to do so, i.e. in the sense that he might place any private Russian company under his control if he wanted to. But he then goes on to hold, and this is the citation that you'll see on the slide. However, I believe the better interpretation of Regulation 7.4 is that it is concerned with an existing influence of a designated person over a relevant affair of the company, not a state of affairs which a designated person is in a position to bring about. Were matters otherwise, it would follow that President Putin was arguably in control for Regulation 7.4 purposes of companies of whose existence he was wholly ignorant and whose affairs were conducted on a routine basis without any thought of him. So in essence, to the relief of many, the High Court has held in a binding decision that the Court of Appeal's observations in Mintz should be understood in the context of the facts of that case, and that Regulation 7.4 is better interpreted as being concerned with the designated person's existing influence over an entity's affairs, rather than a hypothetical state of affairs which a designated person might in theory be in a position to bring about. And then picking up on the calling the shots terminology, Mr. Justice Foxton, and I'm not quite sure how useful this comment is, but he held that Regulation 7.4 is about whether the designated person calls the shots, not whether they call the shots or can call the shots. So in summary, a hypothetical or mere hypothetical right to exercise control is unlikely to be sufficient to meet the Regulation 7.4 test, and Litasco emphasises the need to establish de facto control on a case-by-case basis. That judgment, as I said, was handed down on the 15th of November. Then just 2 days later, on the 17th of November, we have a joint statement from the Foreign Commonwealth and Development Office and OFSI, which broadly aligns with Mr. Justice Foxton's observations in Litasco. In that statement, they said that the incorporation of an entity in a jurisdiction in which a sanctioned public official has a leading role in economic policy or decision-making is insufficient to establish control over the entity. Rather, further evidence of control must be adduced. And they go on to say, if there was sufficient evidence to demonstrate that the designated public official exercises control in Regulation 7.4 terms over private entity X specifically, then the relevant legal test under UK sanctions regulations can be met. So they seem to be suggesting, in line with Litasco, that it is about de facto existing control rather than hypothetical potential control over an entity. But if we just go back to the wording of Regulation 7.4, there nevertheless remains that hypothetical element. The wording is that P would, if P chose to, be able to control the entity in question. And we have to assume that neither Mr. Justice Foxton in Litasco nor the FCDO and OFSI in their published guidance were seeking to do away with this hypothetical element altogether. So where does that leave the wording or the meaning if P chose to? And I think, and I emphasize this is very much one interpretation is open to debate, that perhaps the best way to understand the words if P chose to in light of Litasco is that it has been subject to a sort of temporal constraint or limit, i.e. you're considering whether the designated person could control the company if he or she chose to at present, based, for example, on the company's current management structure, rather than it being a question of whether the designated person could, on some purely hypothetical level, take steps to overhaul the management of the company altogether and bring it under the control of a completely different person or set of persons. But unfortunately, ultimately, the judicial consideration thus far of this regulation hasn't shed much light on the question of when it is reasonable to expect that a designated person could control the company, what all the circumstances means, and the level of due diligence required to ascertain the circumstances. And in the meantime, we can only reasonably pay heed to what is arguably somewhat insufficient or incomplete guidance from OFSI regarding the question of due diligence. And as many of you may be aware, OFSI has published a document which was last updated in December 2023, so fairly recently, which is entitled OFSI Enforcement and Monetary Penalties for Breaches of Financial Sanctions, and you can find that on OFSI's website. And there's no substitute, I'm afraid, for reading that publication in full, but just to note some headline points. Firstly, it's important to note that OFSI will tell you that it does not prescribe the level or type of due diligence to be undertaken to ensure compliance with sanctions. The level of due diligence depends on the degree of sanctions risk and the nature of a person's contractual or commercial relationship with the entity in question. Secondly, OFSI wants to see evidence of a decision-making process that took into account the sanctions risk and determine the appropriate level of due diligence in light of that risk, and to see that such decisions have been made by reference to an internal framework or policy. Thirdly, ownership and control is, of course, not static. So where there's an ongoing relationship with an entity, demonstration of ongoing monitoring is important. And generally speaking, and perhaps this goes without saying, it's supremely important to keep as thorough as possible a paper trail of the research that was undertaken, the sources of information and what they yielded, and the conclusion that was reached and why. And finally, paragraph 3.27 of the guidance obviously gives a non-exhaustive list of due diligence avenues of inquiry that may be regarded as potentially mitigating were a breach to have occurred. And I'm not going to go through these bullet points laboriously, but just to point out a couple of things. The second bullet point, there's the reference to the actual or the potential for influence or de facto control. So just reminding us that of those words, if P chose to, perhaps the reference to potential jars with what we've seen in Litasco and the FCDO guidance, but it's perhaps best interpreted as the current potential for the exercise of control. And the fourth bullet point, which I think is interesting, suggests that depending on the circumstances, it may not be enough simply to conduct open source research on an entity, and that direct contact with the entity should be made, which seeks to shed light on persons who have control or influence, albeit the extent to which that is going to be practicable or going to yield reliable, trustworthy information is highly open to question. But I think the point is to demonstrate that you've at least tried to seek information directly from the entity, and especially from any UK persons who might be involved with or have information about the entity, and to seek commitments from them. And finally, paragraph 3.30 contains very detailed examples of particular areas of inquiry for establishing both formal ownership and control and indirect or de facto control. Perhaps it's worth concluding with the observation that whilst following the OFSI guidance to a T is likely to go some way in terms of mitigation if you were to make a wrong assessment of control of an entity, but that's hardly much comfort when one wants to avoid the risk of enforcement altogether. OFSI guidance, of course, doesn't have legislative force, and so we're still left with much uncertainty as to what is required of us to establish control in the regulation 7.4 sense. And it's, of course, concerning that at the judicial level, there has been quite substantial disagreement about the meaning of that provision. And I understand that various stakeholders have requested the government reconsider regulation 7.4, or consider amending it to formulate the control test in a more concrete way. But it remains to be seen what, if any, legislative amendments may be made.
Yes, well, having heard all of that, it occurs to me that we have, at least on this point, raised more questions than given answers, but I don't think we ever promised clarity or illumination on this difficult point. Just the description of this guidance about due diligence reminds me of something that Mrs. Justice Cockrell, who was the judge at first instance in the Mintz case, said. I'm just quoting here. She says, "It's not the intent for complex investigations to have to be made or evidence gathered, because the list of designated persons should generally set out the persons targeted." Now, I think one can agree with the should, but clearly the list doesn't. And the whole purpose of the various provisions treating parties, entities as though they are designated because of either ownership or control, is meant to catch those situations where people have not been identified as owned and controlled and specifically designated. But I don't know, and I'm very much with you, Chloe, on the very uneasy relationship between the letter of the regulations and what a court might say they mean, and guidance about it, guidance in particular, which might differ in the opinion expressed about what the law requires. I mean, it strikes me that one might find oneself in a situation where one, on the face of it, has breached the law, but obviously, perhaps at most, is saying, well, but in this situation, we probably wouldn't enforce it, which is, I think, a situation no one would want to be in, and seems to me to be rather inimical to our concepts of the rule of law.
I also think the way that Regulation 7.4 and the control test has been formulated is just one example with respect to the views of the Chancellor and other Lord Justices in Mints, does substantively depart from the wording of the EU regulation, which had a much, I think, simpler control test. And the fact that we've reworded it so obviously suggests that it is now meant to be somehow a different test. But in trying to give it more precision, we've actually somehow created more ambiguity.
Well, on that point, I mean, this goes back to what you were saying about the idea that the EU regulation follows the EU regulation by and large. I mean, I was interested to see in the Litasco judgment that Regulation 7.4 is drawn, I think, almost verbatim from something that appears in the Communications Act or the Telecommunications Act. So something dealing with a completely different situation, certainly not sanctions related, but ownership and control in a kind of communications context. 20 years ago or something like that. So somebody obviously thought that was a good idea and it would be fit for purpose, whereas it now appears that the contrary is the case. I don't know, and I really don't know. I'm not hinting that there is, but I don't know whether there's a degree of annoyance amongst judges at first instance with the Court of Appeal in Mints about having thrown the cat amongst the pigeons to quite this extent. But when one reads the Mints judgment, I mean, what is clear is that if they weren't going to do what courts normally do, in other words, exercise a degree of self-denial about expressing opinions about things that no longer arise for decision, they could at least have restrained the aspects in which they talked about it. But the idea of President Putin controlling everything in Russia wasn't even, I don't think, an argument that was raised by the defendants, the Mints applicants. It was used, I think, in argument by the claimants' counsel as a reason why 7.4 should be given a restrictive meaning, because otherwise one of the absurd consequences would be such and such, and then that's picked up in the judgment almost in a kind of throwaway way of saying, well, and if that's the consequence, then that's because the regulations are so badly drafted. Just one other point I wanted to raise, and I know we've got to 11:45, so we're nearly done in terms of allotted time. It's just the question of burden of proof, because that strikes me as being quite a difficult issue. So, I mean, if you and I, on whom does the burden of proof rest in relation to whether someone is owned and controlled so as to be treated as designated? And here again, I mean, there's a significant difference between the UK and EU regulation, because the EU regulation, I think it's Article 11.2 of the 2014 regulation, makes it clear that it's for the party which might be or is said to be designated or owned and controlled to prove otherwise. But the UK regulation doesn't say anything about that. And you would think that the OFSI guidance about due diligence suggests that it must be for the non-designated or not perhaps designated party to do it. But this is a tricky area, it strikes me, Chloe.
Yes, I mean, I think the OFSI guidance is really, on its face, aimed at the situation where you've tried to work out whether an entity is under the ownership or control of a designated person, and you've got that wrong. And it's just about the evidence, whether you've drawn a reasonable conclusion from the evidence that the circumstances you've been apprised of during your due diligence, and whether that due diligence was sufficient. But it doesn't really answer the question. I mean, as I said, it doesn't have any legislative force. It's only for the courts to interpret Regulation 7.4. It doesn't really answer the question of, as you say, burden of proof, and what Regulation 7.4 itself requires in terms of due diligence in order to carry out that reasonableness assessment. So yes, that remains another vexed question.
Yes, just to add to the list. Well, perhaps we better stop there because the list is long and it's now 11:47. Thank you very much for joining us. I have held open the prospect of possible future webinars on other aspects of sanctions regulations. Whether there's any appetite for that, given the obscurity that we have caused, rather than the illumination you hope for, I don't know, but it's definitely something to think about. Good morning.
Good morning.